state of Oklahoma is now in session. God bless the United States of America, the state of Oklahoma, and this honorable court.
Good morning. Please have a seat. The Supreme Court of the state of Oklahoma is now in session. We're convening in the matter of case number 121-497, the Honorable J. Kevin Stitt versus the Honorable Greg Treat and the Honorable Charles McCall. I'm Chief Justice Kane, and I've conferred with counsel briefly prior to our convening. It is the request of the court that we limit our arguments to 30 minutes per side, and counsel have been very agreeable to accommodate that request. My understanding is that counsel have evaluated their needs, and that the petitioner is going to have the first 20 minutes, and then the responding parties are going to divide their time up 12 and 18. The petitioner will get the final 10. So Mr. Pemberton is here for our petitioner, and Mr. Pemberton, you at council table you have very good, very good. Thank you. And then for the responding parties, we have our Attorney General, and let's see, we have his, Gender, help me out here.
Appearing on behalf of the state of Oklahoma, we have Solicitor General Gary Gaskins and Senior Counsel and former Chief Justice of the Oklahoma Supreme Court, Joseph.
Very good. And let's see, is it Denise Lawson is here as well with Mr. Coffey? All right, very good. Okay. Very good. All right, well, do council have any other procedural announcements they would like to make before we convene? Very good. All right. Mr. Pemberton, you may proceed. Oh, and before we start your timer, because council have been kind enough to agree to accommodate the court's time needs, we are going to accommodate council, and we will resolve not to interrupt your presentation with questions. We will wait until you have concluded your presentations, and our questions will not count against your time.
Okay.
All right?
Thank you. May I begin?
Please.
Yeah, Mr. Chief Justice, and may it please the court. The legislature legislates. It creates policy through the lawmaking process. And while it has broad authority to do so, that authority is not without limits. The legislature does not and cannot execute the law once made. Said differently, the legislature can no more execute the law than a football coach who drafts plays can then run onto the field, throw pads on, and begin to execute the plays with the team, regardless of how dissatisfied the coach may be with the player's ability to execute. This case is about the legislature having done the impermissible. It encroached into the executive's clearly defined lane, and it used unlawful process in order to do so. This case is not about minimizing the legislature's authority. No, in fact, it's about recognizing and applying it. We're dealing here with the very core of our state's government function, and whether it will continue to function as it's designed, or if instead, through the will of the legislature and pressure from outside groups, the structure will be forever changed. Our Constitution will effectively having been amended, and customs and statutes amended and changed along with them. The basic questions presented for this court's review are as follows. Did the legislature unlawfully engage in an executive function? And as I'll articulate, the answer to that is clearly yes. The second question, did the legislature use unlawful processes in order to do so? Again, that answer is yes. All we're asking is that this court utilize its jurisdiction to immediately right the wrongs and restore order to the system as designed. I'll address in turn the separation of powers and process issues, but will first address why this court should assume original jurisdiction and remedy the wrongs and do so immediately. I think it's critical to keep in mind as we walk through the analysis that while the parties to this case are this governor and these respondents and this legislature, the fact that they're the specific individuals in those offices is utterly irrelevant to the legal analysis now before this court. So I'll start with jurisdiction. There are two questions, of course, that must be answered. Is there a matter of public interest? And secondly, is there some urgency or pressing need for this court's early intervention? The first has been explicitly conceded at page 4 of the respondent's brief, and the second could hardly be more obvious. But I'll touch on public interest nonetheless. The legislature has consolidated unto itself the authority to both make and then execute the law, and it has done so blatantly. It set aside lawful process in favor of unfettered and convenient discretion. And it has left both the government internally and outward facing, in this case foreign governments, in great confusion with an untenable conflict, something that must be resolved. As we all know, historically, the executive, the governor, has negotiated and entered into tobacco and motor vehicle compacts, and he has done so exclusively. So why is this urgent? You might again hear from the respondents that, well, because the governor can still do today, that is, negotiate and enter into compacts, the thing that he could do before the passage of these acts, that there's nothing for this court to immediately resolve. I would suggest that by having said so, they've done little more than highlight, if not prove the point, that we have two bodies, two government branches engaging in the same function. That's an explicit violation of Article 4, Section 1, Separation of Powers Clause of our Constitution. You might also hear, this court addressed these issues in Treats 1 and 2. It did no such thing. Treats 1 and 2, and I'll delve into those more thoroughly here in a moment, dealt with different issues and different facts. And let me be clear, this is not Treat 3. In the Treat cases, this court was addressing whether the governor violated the law with respect to compacts, but the court certainly wasn't suggesting and never did suggest that the governor could not and wasn't the entity to negotiate and enter into them. And here the question is whether the legislature violated the law with respect to compact negotiations, and it did. The legislature has effectively obliterated the executive's ability to function in this context. If unresolved, a number of questions will remain unanswered as well, and those questions will impact our governmental structure moving forward in a big way. Dissatisfied with an offer from the governor, will foreign governments continue to have the ability to ask the legislature to engage in negotiations about the same compacts that the governor is dealing with? Will governors now and forevermore be left to bid against the legislature and the legislature to bid against governors when it comes to compacting? Surely that is not the system designed and that was intended by our framers. Will the legislature's involvement in this way be a third option, yet another option in which to negotiate and enter into compacts? One being with the governor, everybody agrees that exists. Another perhaps being engaging the Joint Committee after the governor has negotiated and entered compacts. And the third being negotiating and entering into compacts with the entirety of the legislature. That is negotiating with 101 members of the House and 48 senators. That is an untenable system. As for process, do constitutional mandates associated with legislative processes have any meaning? Will they have meaning moving forward? Or will they remain discretionary tools to be used as deemed necessary in a moment? Perhaps the most pressing question that this court would leave unresolved, if not to address this and address this in petitioner's favor, is this. Will real-time issues created by the Executive Act, masked as legislation, be resolved? Real-time issues such as, do the purported compacts or the compact acceptances purportedly being sent to the Tax Commission have meaning? What is the Tax Commission supposed to do with those? We claim that those acts, those compacts that derive from unconstitutional acts are invalid. That's the executive's position, that's the governor's position, and tax right now is left with great uncertainty. That must be resolved. Do terms having been negotiated and entered into with prior governors in tobacco compacts, motor vehicle compacts, do those all have meaning? Or do the amendments that were included in the bills having been passed supersede those somehow? The compacts themselves said there was one way to amend the compacts. That was not done here. That was not utilized here. There's no doubt that this is a matter of imminent public concern, and this court must immediately resolve the issue. I'd like to move to separation of powers. There could hardly be a clearer case of actions repugnant to the separation of powers clause of our state's Constitution. While we happen to be talking about compact negotiations here, we could perhaps just as easily be talking about the governor's clemency power. The governor has the clemency power. If the legislature decided to engage in that same authority and utilize that same authority, leaving for the governor the ability to do the same, is there then no conflict? Is there no urgency because the governor can still do it? Or perhaps let's use something a little bit different. What if the governor, wanting to lower income taxes, entered an executive order saying, I'm stating as governor that the income taxes have been lowered and they're lowered today. Tax Commission, move forward. Well, if the legislature is still left with the ability to do that same thing, is there no conflict? Is there no issue? No, of course there are. Of course, those are clear separation of powers issues. We're dealing with something remarkably similar here. How about the authority to negotiate compacts? Nobody disputes, I don't believe, that the governor has the authority to negotiate and enter into tobacco and motor vehicle compacts, and frankly, others for that matter, whether pursuant to Article 6, Section 8 of the Constitution or pursuant to statute. And I'll get more into that in a moment as well. Quite frankly, the authority itself that provides the governor that authority is significant only insofar as it affects the analysis towards the outcome, but not ultimately the outcome itself. There are some concessions that I think are important to discuss and keep in mind as we move forward. Everyone agrees, as I said, that the governor has the authority to negotiate and enter into compacts. That much is conceded. Everyone, I believe, also would agree that the legislature cannot engage in an executive function and that the executive, the governor, cannot engage in a legislative function. And therefore, if the governor is the one to negotiate and enter into compacts as has been conceded, another branch is having done the same must be engaging in a pure separation of powers conflict. Otherwise, we're calling the governor a policymaker, and everyone agrees that's, of course, not the case. This is a fundamental separation of powers doctrine that we're talking about, enshrined in our state's Constitution and entrenched in this court's precedent. Let me move to the source of authority. I know there's disagreement about whether the source is the Constitution or if it must come from legislative enactments. And while I certainly contend that the source is Article 6, Section 8 of the Constitution, even if Article 6, Section 8 of the Constitution isn't the source, to the extent statute has provided the governor the authority, it has done so. and that has not been repealed, that has not been amended. By the way, I'm not alone in suggesting that the governor's authority stems from the Constitution, Article 6, Section 8. This court, in the Sheffer case, said so in 2013. And it's cited to, in a footnote, I believe it was footnote 18 of that opinion, Article 6, Section 8, and then also Article 6, Section 2, referring to the governor as the chief executive of the executive branch. And then the court went on to reference 3A, specifically the Model Gaming Compact, and even more specifically, the opening line of the Model Gaming Compact, which makes clear that the governor had to have negotiated, and there's a reason that they referenced the governor there. It's because everyone recognized that the governor had the unique authority and the exclusive authority pursuant to Article 6, Section 8. There wasn't a statute prior to that said that the governor could negotiate compacts or negotiate gaming compacts. So if it is statutory, could it be changed, and if so, how? Well, perhaps it could be changed, but it would need to be explicit. They would need to expressly change it. And so perhaps they could look to 68 OS 346, 74 OS 1221 C1, the former addressing tobacco compacts, the latter being the joint committee approach. And they could perhaps remove the governor and replace him with somebody else if you believe that it comes from statute and statute alone. Or they could add somebody else. They could add another party as somebody else they could enter into. That hasn't happened. And by the way, if you look to 1221, what you'll also find is that when the legislature as a whole wants to have involvement in compacts, they say it, and they say it expressly. So what you'll see is in the water law context, they said it expressly. The governor is to negotiate and enter into those types of compacts, but they become approved only once the entirety of the legislature approves them thereafter. Of course, there's no such language dealing with tobacco and motor vehicle compacts. In an effort to legitimize their actions, respondents may argue that they merely made policy, and fiscal policy at that. They did no such thing. And you don't have to take my word for it. Look to the acts themselves, wherein the actions that they're engaging in, they describe as executive acts, and could certainly go through the language, but I would encourage each of you to look to the language, and you'll find it yourselves. Describing the governor having negotiated entered into the compacts as an executive function, and then they went on to do the very thing that they said only he can do, that is, engage in an executive function. So what do we do with treats 1 and 2? Well, again, treats 1 and 2 certainly aren't dispositive of the issue before this court. Very different issue, very different facts. In that case, the claim was, well, the governor entered into gaming compacts that, while maybe, at least with 2 of them, he could enter into, but then he would need to send those to the joint committee for approval. What the court certainly didn't say was the governor has no place in it. And the court certainly didn't say that the legislature as a whole could look right past state law in order to do what it wanted to do, dissatisfied with the governor's approach. Quite simply, different facts, different analysis. There are a number of practical ramifications that this court would have to reconcile and leave on the table if this is left undone. This would be a significant blurring of powers, and to the extent that anybody might believe that this would be a more collaborative approach, something that's actually good, I think, frankly, that would be naive. It would instead be an entirely different form of government, one that hasn't been sanctioned by our Constitution. So what do we do with the concurrent special session? We contend that the special session, having been stood up to run in the midst of an ongoing regular session, is unconstitutional. Can't happen. Special sessions must stand alone. And that only makes sense, and that's also not atextual. Special must mean something. It's not synonymous with regular. Moreover, in a 2013 Attorney General opinion, the Attorney General's office at that time said they're to occur at some time other than the regular session. That, of course, makes sense. And that's to say nothing of the veto powers and what this special session was stood up to circumvent. These bills were passed to the governor within 5 days of sine die, and therefore, pursuant to the Constitution, those bills could no longer be, or any veto of those bills could no longer be overridden pursuant to the Constitution. Surely a separate provision allowing the legislature to call itself into special session can't be utilized or weaponized to circumvent an entirely separate portion of the Constitution related to veto power and veto allocation. That's exactly what was done here nonetheless. Let's move on to the special session call. As you know, we argue as well that the special session call did not include the compact bills. And as you also know, the Constitution provides, and provided as of 1980, in Article 5, Section 27A, the legislature had the ability to call itself into special session. That was conditioned. It was conditioned upon the legislature specifically articulating the purposes of the call. There's no such specificity requirement in the governor's authority to call special sessions. They're different. That must mean something. And so here, you'll see nothing in the call that mentions compacts. You'll see nothing that mentions negotiations. And when we find ourselves trying to squeeze in these acts within one of the calls, the concession has at that point been made that they weren't specifically included within the call. And so for that reason as well, we're asking this court to set aside the acts. If unresolved, if that specific issue is left unresolved, it would convert the constitutional provision mandating specificity into a mere discretionary function as well. The question that would be asked by the legislature moving forward would be this: just how much notice do we want to provide the public? How much notice do we want to provide our own members? How much notice do we want to provide anybody else in this building about the business that we are about to do? That surely can't be a question that's left on the table, and that's obviously not what the constitutional provision contemplated. Some may prefer different negotiation styles, different terms of compacts, or perhaps even a different executive. Those preferential considerations, no matter how strongly held, have no place in the legal analysis before this court. An analysis that calls on this court to ask two questions. Did the legislature engage in an executive function? It did. Did it use unsanctioned process in order to do so? It did. The role of negotiating and entering into tobacco and motor vehicle compacts, that is executing the law, simply is not the legislature's, and it never has been. Having made policy, the legislature's role reached its end as a matter of law, and the executive's began. We're asking this court to set aside House Bill 1005X and Senate Bill 26 as being clearly, palpably, and plainly inconsistent with the Constitution. I stand for questions.
All right, let me ask you. You mentioned that, I believe your statement that this is not treat 3. There was some language, and I think it was treat 2, though, that can be read to say that the governor's compacting authority is exclusively statutory, and one of your propositions is that the statutes violate the Constitution. So I know you addressed it, but would you double back to that again and help me distinguish? Was the statement that I referred to dicta, or was it applying to different facts, or how do you distinguish that?
Yeah, I think two things. I do think that it was dicta respectfully, but even so, let's assume that it does have to derive from statute. The legislature has spoken on the ability to negotiate and enter into these types of compacts, and the respondents have even cited to the statutory authority. They're not even debating that. And those statutes that provide the governor the authority then provide him the authority alone, and that authority has not been amended. But certainly we believe that there's a constitutional issue nonetheless, because they've engaged in an executive function. And of course, if you do that and violate Article 4, Section 1, which sits above, of course, the different branches of government, it lays out how we're supposed to operate. And so, yes, I still maintain that the Constitution provides the governor the authority, and that I'm not the first to say that. This court has also said that before and cited to Article 6, Section 8. Even one of the respondents, at least one, has said it before, and all have operated accordingly. And let's just real quick, I think on that point, speak to the motor vehicle compact that's really at issue. The motor vehicle compacts negotiated and entered into with the Cherokee Nation, Chickasaw Nation, and the Choctaw Nation, those are the three that have compacts in place, were not sent to the Joint Committee. And they were entered into some time ago. There's also not a specific statute saying that the governor is to negotiate those compacts. And nobody is questioning the validity of those compacts to this point. And in fact, the legislature, in their purported acts, seek to reaffirm the compacts. Well, the authority then had to have come from only one place if the authority existed at all. And that would have been from the state constitution, because there wasn't something otherwise laid out in statute, and they didn't go to the Joint Committee.
Thank you. Vice Chief, do you have any questions?
I do. Thank you. Counsel, you cite Schaefer, I think, primarily for your position that this is a constitutional issue. But in Treat 2, we said, as it pertains to Title 74, Section 1221, the executive branch's authority to advocate and negotiate gaming compacts is statutory, not constitutional. Are you asking us today to overrule that finding in Treat 2, and would we not have to rule in your favor if we find that Title 74, as it pertains to today's compact, is constitutional authority?
So I'll address the latter question first, and then circle back to the first as to overturning. So would you need to, I think is the second question, would the court even need to set aside Treat or even any portion of Treat in order to rule in the governor's favor? Absolutely not. And so even if we just set aside Article 6, Section 8, and even if we all agree that the governor's authority to negotiate and enter into compacts does not derive from the Constitution, but must instead be delegated to him by statute, that has in fact occurred here. If you look to Title 68, Section 346, what you will see is that the governor and the governor alone has been delegated by the legislature the authority to negotiate and enter into compacts. At that point, the legislature's role was done and the executives began. That was the executive to execute the law. And so then with respect to 74 OS 1221, also provides kind of a more general authority, I would call it, for the governor to negotiate and enter into compacts, and was pointed to in the Treat cases for the proposition that the governor would need to send those to the Joint Committee. And so in other words, if the legislature, if it strictly comes from the legislature, they must expressly state who's going to do what. And they have done so, and that has not been amended either explicitly or implicitly. Thank you.
Justice Cogger?
No questions.
Justice Winchester?
I would.
Justice Edmondson?
The extension of a compact that has been entered into and negotiated by the governor appears to be rather minimal in its importance as compared to a total usurpation by the legislature of the function of entering into negotiating compacts. Do you disagree?
If all they had done was extend current compacts, I might agree, but I would still claim that that's a usurpation and it's a separation of powers conflict, but that's not all they did here. So they've entered into entirely new compacts as well, not just extended compacts that are currently in place, and then went another step farther in amended terms of compacts as well. So in other words, they interloped, for lack of a better word, into the compacts that are in place and began tinkering with them, changing them. And those compacts were, of course, entered into exclusively by the governor, and rightfully so, whether pursuant to constitutional authority or statutory authority.
It certainly would have disrupted the tactics of the governor in negotiating and entering into compacts. I don't see how the governor could help but resent that kind of, as you say, interloping. But on the other hand, if the legislature perceives the failure of the executive to faithfully execute the responsibilities that have been given to him or her, does not the legislature have a duty to act?
It may have some duty to act. That act isn't to engage in legislative process that's in fact executive in nature. So if they have a problem with the execution of the law, they've come here before and could come here again. Here, we're not dealing with the governor having done something because he's effectively been stripped of the practical authority to do so, even though it still exists in language in the statutes. And so that's the problem, I think, with that theory.
Thank you.
Thank you.
Justice Combs?
Thank you, Chief. Counsel, you have indicated that the entire special session is constitutionally infirm. These two bills, which were vetoed by the governor, and I assume then that you believe that the other 52 bills that were introduced and passed during that special session are likewise constitutionally infirm?
No, I don't, and I articulated that in a footnote in the brief.
Well, the governor's position is that the session is illegally called, correct? No
Correct.
authority to call that session. He vetoes these two. He allows the other 52 to go into law under Article 6, Section 11 without action. And one of those bills is House Bill 1004, which is the general appropriation bill for the entire state of Oklahoma. So is it therefore your position that that general appropriation bill also is constitutionally infirm?
It's not, Justice.
How do you get there?
Sure. So those bills were, the appropriation bills were passed during regular session. And so what I'm arguing is that while the special session itself, because it was constitutionally infirm, goes away, those bills were passed during the regular session before sine die, and they weren't vetoed. Now, the distinction with the bills that we're dealing with here is that they were in fact vetoed. And so as special session goes away, they're passed in the last week of sine die, the legislature, pursuant to the Constitution, no longer has the ability to override vetoes, which is what they did here. But of course, there's other issues with the special session that they would need to wrestle with, that being related to the call.
Would you also agree that if these particular compacts are declared or the legislature's act is invalid and therefore the contracts would expire without any further action, nothing gets negotiated, no extension, they expire December 31st of 2023, there would be a fiscal impact on the balance of fiscal year 24 for the state of Oklahoma because that money collected would no longer be collected?
I don't actually agree with that because that's not the way even that the statutory framework is set up. And that is, there is a provision for non-compacting tribes that's actually being utilized right now. And as it turns out, the state collects more money through that process than it does through the compacting process.
Would you agree that the legislature considered the funds that were going to be paid through these compacts when they made their general appropriation bill? Or that they didn't consider them at all?
Well, I'd be a little surprised if they were considering them that deeply, given the actions.
It's revenue to the state, though, isn't it?
I'm sorry?
It's revenue to the state, though, isn't it?
It is revenue to the state.
All right. Thank you, sir.
All right, thank you, Justice Darby.
Thank you, Chief.
Good morning.
Did I understand you to say earlier that the worst thing would be for this court not to assume jurisdiction and leave this unanswered?
Yes, sir.
Would that be because this is a textbook example of a disagreement or struggle between the legislative branch, the executive branch, and it's the duty of the third branch to resolve it?
100%.
Thank you.
Thank
I'll
you.
waive, Chief.
Justice Keene?
Counsel. You started your comments with staying in your lane, and when I started reading this case, I thought it was very interesting that in the Constitution, Article 6, Section 8, it exclusively gives the governor power to negotiate with certain persons, right? Like states. But would you agree with me that the wording sovereign nations is not in that clause?
I would agree that the word sovereign nations isn't, but even if we look in the appendix at the compacts that were entered into, for instance, with the Chickasaw
Right, but
Nation.
wait, so if that language isn't there, then I do understand your argument, which is, well, we can look at other places to decide if this is a truly an executive function, the fact that there's actually legislation granting him that, what the compacts themselves actually say, but that would be us looking towards an interpretation of the Constitution. Would you agree?
It would. I think I follow. Yes.
Yeah.
That if the authority is not from Article 6, Section 8, then there's other authority out there to look to.
No, I'm saying
Oh,
if the
okay.
wording specifically textually isn't in Article 6, Section 8,
I see.
that we can say, well, maybe the conventioners just forgot to mention Indian tribes, but it only makes sense to interpret that constitutional clause to say, if he has the power to negotiate with these people, the Constitution would also give him power to negotiate with tribes, because we can look at all these historical things and everything surrounding that clause that would give him that executive power as well.
Yeah, and I think
Is
to
that where you
piggyback
want us to
maybe,
go?
yeah, to address maybe just one point in there, you said maybe they forgot, and as we've pointed out in the brief, I mean, the tribal governments at the time that our framers were creating the Constitution effectively weren't there at that point, and so it would have been odd, nonsensical to include them. And so then moving forward through history, though, everyone for a long, long time operated under one assumption, and that was that the governor had the authority to negotiate and enter compacts.
Right, so
and it's
looking
from
at
the
history
Constitution.
to interpret. But
Yes.
here's my next question. If that is in the Constitution itself, and I really am interested to hear your comments, why the legislation? Why did the legislature have to make a statute to grant that authority when those other compacts were made, if the Constitution already gave the governor that exclusive executive authority?
Yeah, it's never out of the ordinary, of course, for the legislature to pass laws that are consistent with the Constitution. In fact, they must. And so, you know, perhaps they expanded upon some things, but they certainly didn't say that the governor is not to. In fact, they executed laws or submitted laws through the process, 346 and 1221 here, with only the governor in mind as being that to negotiate these types of compacts. And so therefore, they entered law consistent with Article 6, Section 8.
Okay. And last question, even if he doesn't have an exclusive constitutional power to do so, unless there's a constitutional amendment maybe by the people, there is legislation in place that gives him the authority to negotiate the contracts, correct?
That is absolutely right.
Okay, I waive.
Right. Thank you, Mr. Pemberton.
Okay, thank you.
Is the Attorney General or Mr. Coffey going to go next? Mr. Attorney General. You may proceed.
Mr. Chief Justice, Mr. Vice Chief, and Honorable Justices, may it please the Court. I appear today as the state's Chief Law Officer for the citizens of Oklahoma. The Governor's application of this Court to assume original jurisdiction must fail on two grounds. First, This court has already addressed the governor's constitutional and statutory authority in Treats 1 and 2. And secondly, the governor cannot identify any injury to his office because, by his own words, he continues to negotiate with the tribes on compacts even after the filing of his petition. To prevail, he must show that the legislature's actions were, quote, clearly, palpably, and plainly inconsistent with the Constitution. To prevail, he must also do more than just simply allege that the Constitution does not expressly authorize the legislature to act. Rather, the governor must instead show that the Constitution expressly prohibits the legislature's actions. On both of these points, he cannot meet that burden. Article 5, Section 36 of our Constitution requires judicial protection of legislative power. And if there is any doubt to the legislature's power to act in any given situation, the doubt must be resolved in favor of the legislature, as determined in Draper in 1980. The governor confuses his executive role with that of the United States President, but our constitutional drafters created a decentralized Oklahoma executive branch, as evidenced by my independent role and that of other statewide executive officers. And it intentionally created a weak state chief executive, principally because we did not trust too much power with one person. The governor relies on Article 6, Section 8. However, this reliance is misplaced on three substantive grounds. First, it is prescriptive, as Justice Cogger explained in Treat 2. It is also not exclusive by its own language. And third, the tribes, as Justice Keene pointed out, are not mentioned in the constitutional text. Rather, quote, other states and with the United States. On a statutory basis, the governor's reliance on Title 68, Section 346, and Title 74, Section 1221 is misplaced, and therefore it also fails. Title 68 does not vest the governor with authority to control the terms of the tobacco tax agreements. Rather, he is simply authorized to enter into compacts. Again, this statute is limiting. He may only enter into, but cannot control the terms. Further, nothing in the statute suggests that the legislature ceded or limited its own power, or that that power is exclusive to the governor. It is the delegator to the delegatee. Title 74 simply gives the governor a general authorization, quote, to negotiate and enter into agreements, close quote, with tribes, which again is not exclusive. We need look only to examples like the Indian Child Welfare Act with DHS, or the tribal license plate designation delegation to the Director of Service Oklahoma. Lastly, the governor relies on the 2013 Schaefer versus Buffalo Run Casino. But Schaefer is inconsistent with Treat 2, where this court found that his authority to advocate and negotiate compacts is statutory and not constitutional. The governor attempts and fails to characterize Senate Bill 26X and House Bill 1005X as an exercise of executive power. But these challenged acts are consistent with how Oklahoma has always operated with compacting with tribal nations. For example, Senate Bill 26X simply continues, as Justice Edmondson pointed out, the legal effect of the tobacco products tax policies codified in Title 68, Section 346. Not Section 349, which would be triggered in the absence of a compact. By passing 26X, the legislature avoided the uncertainty in administering Oklahoma's tax laws, and it avoided an adverse budget impact, as Justice Combs points out, in tens of millions of dollars by simply extending the termination for 1 year, thus giving the governor additional time to negotiate during his tenure. Based on the foregoing, I believe the court should deny original jurisdiction in this matter. If, however, the court grants original jurisdiction, my objective is for this court, once and for all, to define the proper division of power between the legislature and governor when it comes to compacting with tribes. I, along with the legislature and our tribal neighbors, believe that this court has definitively resolved these issues in Treat 1 and 2. In those cases, the court made clear the governor's authority to negotiate with compacting in the tribes is statutory not constitutional, and it was not dicta. The governor attempts to distinguish Treat 1 and 2 as relating only to gaming, but the clear conclusion of these cases is that the governor's negotiating power with the tribes is statutory. The governor has not provided this court any reason why he should or has enlarged powers in tobacco or motor fuels compacting versus gaming. We are instructed in Attorney General Opinion 2020-8 that under the separation of powers doctrine, the legislature sets policy via statutes, and the governor plays a role in the legislative process through his signature or his veto. And in this case, he vetoed both new statutes, and the legislature successfully overrode the governor's veto. Therefore, there is no reason for this court to invalidate these acts. I do recognize that the legislature previously granted the governor statutory authority to, quote, negotiate cigarette and tobacco products tax compacts in Title 68, and, quote, to negotiate and enter into cooperative agreements, close quote, in Title 74. However, neither of these statutes gave the governor exclusive authority to negotiate. Under the Constitution, quote, the authority of the legislature shall extend to all rightful subjects of legislation. And as a result, there is no restriction on the legislature's authorization of extending the compacts when the governor failed. The governor suggests that the legislature should have repealed the governor's statutory compacting authority before taking it upon itself to extend these subject compacts. But again, the governor's statutory power to negotiate is not exclusive. Therefore, any such repeal of prior statutes was not required. And there is no reason for this court to referee between the two. The governor also makes some argument about the manner in which the legislature passed these two acts, and in our brief, we deferred to the legislature to defend itself on these arguments. However, after reviewing the governor's and the legislature's briefings on the issue, it is my opinion that the legislature acted appropriately in passing these challenged acts. First, there is no express time limitation found in Article 5, Section 27A. Therefore, it is my opinion that there is no constitutional limitation on a special session running concurrently with a regular session. In his brief, the governor selectively misquotes, and Mr. Pemberton misquoted today, the 2013 Attorney General opinion claiming that the opinion stands for the principle that special sessions, quote, may be convened at some other time than during the regular session. But this sentence fragment actually stands for the opposite principle. Read in full, quote, the Constitution does not place a time restriction on when a special session may be called by the legislature. 2013 AG Opinion 8 at paragraph 20. Also instructive on this point is the 2017 AG Opinion, which concludes that Article 5, Section 33's restriction on the passage of a revenue bill during the last 5 days of a legislative session applies across the board, regardless of whether the legislature was convened in regular session or special session. And that conclusion, quote, does not change if the date of passage happens to coincide with the last 5 days of a regular session running concurrently with a special session, close quote. Second, the governor complains that the legislature wasn't specific enough in its call for the special session, and this is unfounded. The legislature identified, quote, implementing and administering budget-related funds, close quote, as one of its purposes. The extension of the subject compact is a collection mechanism which avoided a negative budget impact of over $57 million. Therefore, Senate Bill 26X and House Bill 1005X clearly fall under the specified category of, quote, implementing and administering budget-related funds. Moreover, the governor has failed to cite any case law or other persuasive authority that the legislature must identify every possible budget-related item it wishes to address when calling a special session. This court has previously made it clear that, quote, a legislative act is presumed to be constitutional and will be upheld by this court unless it is clearly, palpably, and plainly inconsistent with the Constitution. absent any plain legal authority identifying the degree of specificity required when calling a special session, the passage of the challenged acts are constitutional. In conclusion, there is nothing in law, in policy, or in fact that supports the governor's invitation for this court to unsettle Oklahoma's legislature's good work. On behalf of the citizens of Oklahoma, we ask you to deny original jurisdiction, or, in the alternative, that if you assume original jurisdiction, you deny the governor's requested relief and let the Oklahomans enjoy the benefits of its many compacts with our tribal partners. Thank you. I yield my last minute to Speaker Senator
Mr. Attorney
Coffey.
General, let me ask you.
Yes, sir.
Mr. Pemberton spoke about the specter of branches of government bidding against one another. Might the uncertainty as to the validity of these two new bills deter our compacting partners from finalizing any agreements until we have an answer to the question?
I think that our compacting partners in this given set of facts are relieved that the legislature extended the compacts. And I don't think it deters them one bit from continuing to negotiate with the governor. I base that on personal conversations with over 30 of the tribal leaders of our 39.
Mr. Vice Chief?
Yes, thank you. Good morning, General Drummond. It seems like over the last 32 years, the governor has negotiated. This is the first departure that I've heard or read about in the briefs, the one before the court today. And whether the governor over the last 32 years has negotiated by statutory right or constitutional right, it has been the governor to do so. So taking your position that this is purely a statutory right that the governor has acted upon the last 32 years, would you not agree that the statute delegating that authority does not contemplate the legislature taking it back from the governor? And if the legislature chooses to do so, they must amend the authority by which they seek to do so, and they have not done that, have they?
I disagree with your analysis. I think that the legislature is embodied with the power of the people to pass statutory law, and in this case, it delegated an authority to the governor, just as it delegated to DHS, the Indian Child Welfare Act, and it delegated to other bodies.
It delegated the authority to the governor, and it took it back without changing the statute. You would agree with that, wouldn't you?
I would agree with that, and I would state that it had no duty or legal obligation to amend.
Thank you.
It is the delegator.
Thank you.
Certainly. Thank you.
Justice Cotter?
No questions.
Justice Winchester?
If the legislature could step in at any time and pass any legislation during the term of a contract, the duration of it, if they could do that any time, what incentive would any governor in the future have to negotiate a contract in any executive branch?
I think that if, in the present circumstance, the governor had successfully negotiated an extension of the compacts, you would not have found the legislature stepping in.
But you understand the
But
practical
in this
problem
case,
is...
in this case, he did fail.
Between the two, if one says, well, I can trump that and take that away, there'd be no reason if you were an executive branch to contract.
I think that if the legislature decided to delegate all compacting authority to the labor commissioner, it could do that. And the labor commissioner could proceed in compacting, as to any other party of the executive branch. And I think that the governor is uniquely and perfectly equipped to negotiate on behalf of the state. But he did not, and the time ran out. And it was a $58 million budgetary deficit that the legislature had to step in.
I have no questions.
Justice Edmondson?
If the governor finds it in the interest of the state to continue to compact with one of the tribes, and the legislature gives him more time to do that without a compact having lapsed during negotiations, is that a usurpation of the governor's authority?
Certainly not.
I tend to agree. Thank you.
Certainly.
Justice Combs?
I waive, Chief. Thank you.
Justice Darby?
So do I understand you to advocate doing what Mr. Pemberton says would be the worst thing for us to do? That would be not assuming original jurisdiction and just leaving things as they are.
Right. I think that you could, if to the extent you assume original jurisdiction, we're going to have what we will subsequently call Treat 3, where this court tells the governor for the third time what to do. So I don't see any necessity for you doing that. You do not need to assume original jurisdiction.
Well, how would you or anybody else know that that was our position if we don't assume original jurisdiction and say so?
I am very comfortable to rely on Treat 2, where Justice Cogger made clear that the power of the governor is statutory and not constitutional.
So the legislature, in your opinion, can dictate what the governor can and cannot do?
I think that that is an overstatement of what I would suggest. Rather, the legislature delegated to the governor the authority to negotiate, but it was not exclusive, and it retains the power to redelegate if it so needs. I don't believe, as Vice Justice Rowe suggested, that the statute would have to be repealed. The delegator has the power.
To undelegate.
Correct.
Thank you.
Justice Keene?
Good morning, Attorney General. Just a couple of questions. I found it interesting when you said that he's not allowed to negotiate the terms of any compacts. So the legislation and the statute, if it doesn't give the governor the right to determine the terms, how will that process work? Is the Senate Pro Tem and the Speaker of the House going to get together and say, whenever they want, we'd want to renegotiate these. Let's write up the terms, give them to the governor. He can walk across the street, whatever, show the tribes what terms we want, and then he presents them and then we get to decide if he messed it up or not. How would that, if you're saying that the governor can't negotiate terms, who gives us the terms?
The statutory authority illustrates, and I think the more poignant example would be in the gaming world. So all gaming is illegal unless it is authorized. It's a covered act. And we know from Treat 1 and 2, the governor went outside the parameters of the covered acts, the covered games, and enlarged them. That was unconstitutional. That was violation of the statute. The governor did not have the liberty to go beyond what the legislature said. In this case, the legislature has said, we authorize a compacting for money in lieu of tax on tobacco products and motor fuels. And the governor has to stay within those parameters. Not that his negotiation, the legislature did nothing to enlarge those terms by simply continuing the compact that it had previously authorized the governor. But it gives the governor parameters.
As a contract negotiator yourself, I know that you're a talented attorney. I'm sure when you enter into negotiations that one of the tactics is always to walk away from the table. And instead of, like Justice Edmondson suggested, which I agree with, that you could give the governor more time to negotiate, it also might be that the governor has decided that he, as the negotiator, is stepping away in order to get better terms for the citizens of Oklahoma. Is that a possibility, and why is that not within his negotiation power?
I think the reality is what he was seeking was a compacting fix to satisfy his disgust with McGirt. He was wanting the tribes to waive sovereignty in certain areas that they were unwilling to because the United States Supreme Court has said otherwise. So you're right, he did exactly that. He played hardball and walked from the table. And it only would have cost the state $58 million, as it has cost us $7 million in the hunting licensing, an untold future if the legislature does not act where a governor fails the state. And this governor failed the state.
So, one more question. I find that statutory interpretation is very important, and the words the legislature use are important, and they use the word negotiate here. That means something to me. That means you go in and you sit down at the table and you talk terms and you hash it out. Not that somebody else tells you what you have to say like a puppet, but you have the authority to go in and negotiate for the other person, like the legislature. Why, if he is only, what I think you're arguing, that he is just really a signatory, why isn't the word ratify?
That's not what I'm suggesting, Justice
Okay.
Keenan. What I'm suggesting is the legislature set parameters. Back to my example of the covered games. Similarly, if he said, well, in addition to tobacco, I'm going to enlarge it to include marijuana, that would be an abrogation of his authority. He can't do that. He is limited to negotiating tobacco products. Now, can he negotiate a higher percentage? Certainly. Can he get a larger, longer contract? Certainly. That's the negotiation that is contemplated in the statute, not that he enlarge it beyond what is authorized.
Okay. So remind me again, sorry I said last question, but now I'm curious. What specifically with the governor not wanting to extend these contracts violates the parameters of the statute?
They would have lapsed.
How is that against the statutory language?
I beg your pardon?
How is that against the statutory language or perimeter, him just letting it lapse?
Oh, no, clearly, he did. His actions, he failed. The legislature concluded, and I can't speak for the legislature, but it appears as though the legislature's concern was, we're not back in session until February. These contracts will lapse December 31. We must act where the governor has failed to act. I think it was responsible. And if Roger Thompson were here, the A&B chair for the Senate, he would say, I planned on that $58 million, I needed that $58 million, and to lose it, then we would have to cut services.
So when they went in to amend the statute, and I think negotiate with the tribes, when they passed or overrode the veto, why didn't at the first, you might not know this answer, why at the first didn't the legislature just amend the statute like Justice Rowe suggested to say, guess what, Governor, we don't like you as a negotiator, we're taking it on, and we're going to put Speaker Pro Tem in charge of negotiating compacts. Isn't that the resolution? Because if not, aren't they violating their own statute? Because they're not the negotiator.
I think they simply extended the term, 1 year. They could have extended it 3 years. If they truly believed this governor had an inability to compact, they would have extended it 3 years and gotten to another governor. They gave it 1 year, acknowledging that he continues to negotiate. And I hope, for the good of the state, that he does negotiate successfully on all compacts.
Thank you.
Certainly.
I waive.
Our senior justice has a question.
Are they still negotiating? Don't they still have 24 days before the time runs out?
I believe they do. I know that an offer has been made to the tribes via the legislature, and they may accept that offer through the tax commission, and I don't have the competency to tell you if they've accepted those yet or not, but I anticipate fully that they would. However, I believe if the governor came to the tribes right now and said, hey, I want to reassert my position and I will simply continue these 1 year, that would be viable and valid.
Thank you, General.
Thank you.
Any other questions? Thank you, sir.
Mr. Chief Justice, Justices, may it please the court, there are two narrow issues before the court today. Does the legislature possess the inherent authority to pass the legislative acts, and were the acts properly considered during special session? The answer to both of these questions is yes. Before I address these, I do want to spend just a moment on the standard of review or the presumption of constitutionality, as was briefed. And let me also precede that. I'm not going to address the jurisdiction questions. I believe you've addressed them. We're here today arguing the merits, so it would just, given the limits of our time, I'm going to let the brief stand for itself on those issues, but happy to answer any questions. But as to the standard of review, the governor does have to overcome a strong presumption in favor of the validity of the legislative acts at issue. As this court stated in Calvi v. Daxon, if there are two possible interpretations, one of which would hold the legislation unconstitutional, the construction must be applied which renders them constitutional. This is particularly true of legislation with direct fiscal impact, as this has. Except where it encounters, quoting again from the same case, except where it encounters a specific constitutional prohibition, the legislature has the right and the responsibility to declare the fiscal policy of the state of Oklahoma. I first would like to go to the legislative session issues. Both the special session itself and the measures of the legislature that the legislature considered and approved were consistent with constitutional requirements. The Oklahoma Constitution does not prohibit special sessions from running concurrent with the regular session. Article 5, Section 27A, which was adopted by a vote of the people in 1980, contains 3 requirements, and 3 only: that the legislature must meet to convene itself into a special session. A call that sets forth the specific purpose of the session. 2, signatures of 2/3 of the members of each chamber. And 3, an order from the President Pro Tempore and Speaker of the House. The 3 specified limitations are the beginning and the end of the constitutional restrictions on the legislature's authority to convene itself into special session, and none of these restrictions relate to timing. In fact, the only case law cited by the petitioner predated the adoption of Article 5, Section 27A by the people, which for the first time allowed the legislature to call itself into special session. Petitioner relies on a selective quotation from AG Opinion 2013-8, which has already been discussed by the General. I would just simply say that as such, based on the case law, based on the opinions that have been discussed and briefed, it's consistent with this court's long precedent of giving effect to the intent of the framers and the people adopting it, as it did in Shaw v. Grumbine. The petitioner's claim that there is an additional timing restriction on special session is without merit. 2, the legislative acts were properly considered during the special session. The petitioners claim that Senate Bill 26X and HB 1005X were improperly considered under the special session call is also without merit. While Article 5, Section 27A requires that special session be called in written form for purposes that may be specifically set out in the call, there is no requirement that the legislature must articulate measures in exacting detail. Here, the legislature's call for the first extraordinary session of the 59th legislature included legislation related to implementing and administering budget-related funds. As noted in the bill summaries, each of the legislative acts, both bills unquestionably had an effect on state revenue, thus making them eligible for consideration under the special session call. As noted in our brief and in the discussions today, under the Tobacco Compact, the state of Oklahoma realized a budget impact over $57 million in fiscal year 2022 alone. It should be noted there's been some discussion and some questions about whether the legislature considered the $57 million. The legislature has to certify specific funds and where they come from to accomplish the constitutional requirement of a balanced budget. So it absolutely had to consider those funds in that question. As to legislative power, broadly, the governor claims the legislature did not have the proper authority to enact Senate Bill 26X and House Bill 1005X, based upon 2 faulty assumptions. 1, the acts violate his authority under Article 6, Section 8 of the Constitution, and 2, the acts are inconsistent with other statutory provisions. Both arguments, as discussed, rest on the premise that the governor somehow possesses supreme authority to enter into compacts to the exclusion of the legislature. This ignores that fundamental principle that the court has consistently declared when analyzing legislation, that the legislature has the constitutionally endowed authority to set the public policy of the state, Article 5, Section 36. Also, I think it's important to note what this case is not. This case is not a retraction of the governor's authority. As Justice Cogger noted in her question, there has been no violence done to the governor's ability to continue negotiations and to try and compact. That remains unchanged. What the legislature didn't change that authority in any way, shape, or it simply created another method under its legislative powers under which the compacts could occur. But it did not take away the governor's ability to do the same. He still has that. And there's been plenty of publicity in the news about ongoing negotiations, and I'm not party to those. I have no inside knowledge, but we know that it has continued. It just hasn't resulted in a compact. First of all, the legislature's act does not violate the governor's right under Article 6, Section 8. The court has previously analyzed the governor's authority to enter into compacts with Indian tribes, unequivocally declared that his rights are statutory, not constitutional, in Treat 2 and in Treat 1. Notably, these decisions were not decided because of federal law implications, but on state law, separation of powers principles. Indeed, the legislature maintains the authority to set the public policy of the state, as it did here, and the governor is charged with enacting that policy. 2, the statutes are subject to amendment, which is what occurred here. I can tell you firsthand that a piece of legislation is not a fine work of art to never be touched again. It's amended with great regularity when errors are found, facts change, circumstances change. It is the duty of the legislature to inspect what it has passed into law in previous sessions and make modifications accordingly. That's what they did here. The governor claims that his statutory right to enter into compacts under the relevant statutory schemes has somehow been infringed by the passage of the legislative amendments to those acts, but there are some fundamental problems with this characterization. First, even if it's true, the legislature remains free to amend statutes and enlarge or constrict any statutory authority that executive branch officials possess under a specific statute. Second, this argument ignores that the governor possesses the same authority as he had prior to the passage of the legislative amendments. As I've stated numerous times, he remains free to negotiate tobacco and motor vehicle compacts consistent with the statute. As Justice Cogger noted in her concurring opinion in Treat 2, the framers of the Oklahoma Constitution intentionally created a chief executive with limited fragmentary powers. This was reaffirmed again in the 2021 opinion of this court in Tulsa Spine and Specialty Hospital. Ultimately, all statutes can be read together to avoid any conflict, consistent with the requirements of statutory construction. Tribal governments have 2 options related to extending their compact with the state. Option 1, the tribe can negotiate renewal with the governor, who can then execute the compacts pursuant to the existing statutory provisions, allowing him to do so. Specifically, 68 OS 346. The other option is the tribe can choose to extend the compacts under the new statutory provisions. And we know that at least 6, based on my research with the Secretary of State's website, have availed themselves of that opportunity. Ultimately, though, any claim by the governor that he has exclusive authority, I think it is of note that counsel for the governor today has retreated from the use of the word exclusive that was prevalent in both his briefs. I may be wrong, but I didn't hear that word today in his argument. Under statute, to enter into compacts ignores that the premise of his authority is statutory and thus subject to legislative amendment as it occurred here. The legislature took the steps it felt it needed to take to protect the state's interest in continuing the compacts that form an important component of the budget and our relationships with tribal partners, and the governor has suffered no actual harm here. In conclusion, the governor can point to no limitation in the Constitution itself that prohibits special session from running concurrently with the regular session. Likewise, given the revenue implications of the compact, we believe the legislation was properly considered under the special session call. The governor's remaining arguments relate to substance of the compacts, and we believe those compacts fall squarely within the legislature's purview. I would note that what we're not here today talking about is whether the legislature chose to or whether it would revoke those powers. That's a different set of facts for a different case. Thus, his power is subject to legislative amendment. But importantly, as his counsel admits, he is continuing to engage in those discussions, so any authority he does possess under the statute remains. As such, the legislature respectfully requests that this court hold in favor of the legislature's authority, consistent with our constitutional structure and separation of powers considerations. I would gladly yield to any questions at this time.
Thank you, sir. Mr. Vice Chief Justice?
Counsel, is it your position that the legislature can extend the existing provisions but cannot modify them?
I don't think I think they did modify two provisions with this amendment.
I thought I understood you to say there's two methods that the tribes have. Negotiate with the governor, new terms, or number two, extend the existing provisions by legislative authority.
As a result of these two measures that passed in special session, it creates that second alternative.
Doesn't that create a third one, or negotiate with the legislature, new terms?
The legislature
is that what they did?
The legislature has not argued for that and has not asked for that.
I'm asking, is that what happened? Are these new terms or simply an extension?
I think they're an amendment to the existing compact, which 6 nations have availed themselves of.
And the terms remain exactly the same?
They do not. They're modified.
Thank you, Chief.
Justice Cogger?
No questions.
Justice Winchester?
Waive.
Justice Edmondson?
I'll waive.
Justice Combs?
I'll waive.
Justice Darby? Justice Keene?
Good morning.
I have a couple of questions. You are bringing up the amount of money that's at stake here. Are you asking the court to go into the negotiation room? Because I'm assuming I was pleasantly happy when the Attorney General said, you know, this is what's going on here. McGirt, the word we all hear in Oklahoma all the time now, is on the table. But I don't know if that's in the record for consideration, or the fact that we might not know what the governor might be arguing, that certain other aspects of McGirt are going to strip the state's citizens of money in other places. In other words, he might be negotiating because he's worried about that. So do you think it's necessarily within this court's purview to be considering what the governor's gonna, what might happen if these compacts aren't extended right now? Is that something we should consider?
Well, to specifically respond to your question, am I suggesting the court should enter the negotiation room? Absolutely not. That's not my intent with these arguments. As to what the governor might put on the table in future negotiations, I think that's between the governor and the party he's negotiating with. That's how we got the gaming compact in the first place.
But are you mentioning the amount of money to make us worried that that's the end-all be-all? I mean, is that something we should be considering?
I'm mentioning the amount of money to say that if the governor were to prevail, the budget would be out of balance. We're well into this fiscal year, and it would create harm to the state to consider it at this time. For no other reason. I'm not using it as a club or a shield or a sword.
Okay. Last question. The same thing I asked the Attorney General. You said there's no violence, I think you said, or harm to let the governor continue to negotiate. But Mr. Coffey, I can tell you when I was growing up, if I wanted something, I surely knew who pulled the strings in my house. And I went to my dad because I thought he'd easily say yes. But I knew for sure that I got to talk my mom into it, because at the end of the day, she's the one controlling the terms of whatever contract I was making with my parents. How is that not the same to say, in other words, when I would go, I knew that my dad didn't have anything there's no power there. I need to go to this person. How is what you're doing to the legislature doing to the governor here not that same scenario? How is it not harmful to take away the actual negotiation of terms or to walk away? The tribes can just say, yeah, we don't care what your next offer is. We're just going to go to the legislature because they're going to do what we want. How is that not happening here?
Justice Keene, it would be pure conjecture on my part to speculate in the minds of our tribal partners what they might think of that. But we don't have to speculate because the facts disagree with your speculation. They've stayed at the table. They continue to negotiate. There are press reports to that effect. Counsel for the governor has stated that in his briefs, so that simply hasn't been the case here.
Okay. Shoot, I lost my question, which means I guess I have to waive. Thank you.
Thank you.
Any other questions? Thank you, sir.
Thank you.
Well, Mr.
I haven't heard my question. I'm so sorry. Everyone's going to kill me. They're like, stop talking, Justice Keene. Wow, that was much. Okay, one thing. Is it possible, would you agree with me that the legislature could go in and amend the statute and say, we don't want the governor to negotiate for us anymore? They can do that.
I believe they have that power, yes.
Okay, sorry. Sorry about that. Thank you.
Thank you. And Mr. Pemberton, the governor is our petitioner, gets the last word.
Okay, thank you, Justice. It's remarkable to me that they continue to stand up here and concede expressly that two branches of our government can do the same exact function. That runs directly counter to the separation of powers clause of our Constitution. But they say it over and over again, and then they provide the rationale. And the rationale is, well, the governor's not getting it done, or there's going to be some loss of revenue. Neither of those things are objectively true. Let me speak to the money. The figures that are being thrown out are not objective fact. But regardless, they have absolutely no relevance in the legal analysis before this court, which is simply, did the legislature engage in an executive function? And they did, and they used unlawful process in order to do so. I know there's been some discussion about Section 346 and what it says or doesn't say. I'll just read the pertinent language because I think it's remarkably helpful here. The governor is authorized by this enactment to enter into cigarette and tobacco products tax compacts on behalf of the state of Oklahoma with the federally recognized Indian tribes or nations of this state. Now, this next phrase is critical because there's been debate about whether the governor gets to negotiate terms, which they always have, and seems to have been conceded in part again, but maybe not. The next phrase, the compacts shall set forth the terms of the agreement. In other words, the governor is to enter into these things, and the governor and the tribe are to establish the terms of the compacts. And so how do you come up with terms? Well, of course you negotiate the terms. So, and you find even clearer language in 74 OS 1221, providing that the governor is authorized to negotiate and enter into cooperative agreements. Mr. Coffey mentioned that perhaps we had ran from the exclusivity of the governor. We have not. Certainly, whether pursuant to the Constitution, or even if you don't adopt that theory and you say that the legislature must delegate it, the legislature has, in fact, delegated then that authority, and it has given the authority exclusively. They point to, and this is actually helpful, some DHS compacts or agreements that they can enter into with tribes or other entities that may be able to enter into agreements with tribes. All that highlights is that when the legislature says that a certain body or a certain agency or a certain individual is the one to do something, they are in fact the only one to do something. Or said differently, if the legislature wants to articulate a different process for compact negotiations in this specific context, If you don't accept that it is pursuant to the Constitution, they still must change the law, and they've not done it. And they effectively concede that. The reality is, and it seems important to some, and I appreciate that the governor has been strenuously trying to engage in negotiations. However, because of what we're dealing with here, and to Justice Keene's point, we have gotten effectively zero substantive response to compact offers, remarkably legitimate compact offers, sent out to all 38 federally recognized tribes. That wasn't just yesterday, that wasn't this month, it wasn't last month, it was months ago. And why wouldn't the tribes be inclined to engage the governor at this point? Because of what's happened here. And to Justice Keene's point, until they're told that the law means something, until we're all told that the law means what it says, and that when something is put in statute, if it's statute that provides the authority, when it's put in there, we must all abide by it. And that's all we're asking, is that this court vindicate the law. With respect to the special session call, I'd like to touch on that momentarily. There's been argument that, well, these were budget related, and of course they were budget related, there was revenue and so on and so forth. The respondents actually, in a brief filed in a separate case, ran from that approach and said, no. The purpose of those was not the budget, and that's the case filed by OCPA against these respondents. The purpose was not budget, it was the compacts, not budget at all. And so certainly there, I take their word for it, and I trust the candor having been provided to this court in that context. I would ask you to take their word as well. All you have really heard is that they don't like the governor's position. They don't think he can be effective with tribes. None of that has any bearing on the legal analysis. I can't separate them from their emotions. I can't separate them from strong feelings towards the governor or anybody else. And fortunately, those feelings, those emotions, those opinions that they may hold about how a certain individual operates have no bearing on the legal analysis, which again calls for this court to determine whether the legislature engaged in an executive function, and they have effectively conceded that, and conceded it time and again. I'd like to wrap up by looking back to the acts themselves. If you look to 26X dealing with tobacco, Senate Bill 26X dealing with tobacco compacts, they start by saying the legislature finds that as codified in Section 1221 of Title 74 of Oklahoma statutes, Oklahoma's standing policy is to work in a spirit of cooperation with the Indian tribes. They then go on to paragraph 2. Oklahoma has benefited from its implementation, synonymous with execution of this policy, through, among other things, the formation and entry of intergovernmental agreements or compacts with tribal nations on a variety of subjects. In other words, they say at the front end, the policy is to cooperate with federally recognized tribes. They then go on to articulate very clearly what it means to execute on that aspired policy. And just after that, they go on to execute themselves by entering into altogether new compacts as well as amending compacts that are in place right now. And you find remarkably similar language, if not more profound, in House Bill 1005. The legislature finds that Oklahoma has benefited from its implementation of the policy set forth in Section 1221 of Title 74. They then go on in paragraph 2. As an exercise of executive authority. Consistent with this codified policy, the Oklahoma governor formed and entered certain tribal state agreements. They themselves describe it as executive authority. The legislature simply cannot engage in an executive authority, regardless of how badly we may feel or how strongly we may feel about the governor's position, whether this governor or governors in the legislature into the future. And with that, I'll stand for questions. Thank you.
Thank you, sir. Mr. Vice Chief Justice. Senior Justice?
What you just read said enter into. I don't recall you reading negotiate in that last.
In Title 340 or Title
Whatever
68?
you just read just a minute ago.
Yeah, so the second sentence of that says the compacts shall set forth the terms of the agreement. And I don't know how else one gets to terms but for negotiating.
There was the part about entering into.
The first sentence, yeah, assuming I'm looking at the section that you're referencing. I'm looking at 68 OS 346, which deals with tobacco compacts. The governor is authorized by this enactment to enter into.
See, it doesn't say negotiate.
Well, the next, it doesn't say the word negotiate. The next
No, it
sentence
doesn't.
Right, it doesn't say the word negotiate.
Right, thank you.
And what, the next sentence was what?
The next sentence is the compacts shall set forth the terms of the agreement. That means something, and it has meant something historically. What have the governors and the tribes done historically? They have negotiated and entered into compacts. They have negotiated the terms, and in fact, respondents stood up here and said that the terms of the compacts can of course be changed, certain terms, by the governor. And so that they of course can, he of course can, and has been given exclusive authority to do so. Thank you.
Thank you. Justice Winchester?
Waive.
Justice Edmondson?
Waive.
Justice Combs?
Waive.
Justice Darby? Justice Keene? All right. Well, counselors, I threw you a bit of a curveball this morning by adjusting the amount of time for your argument because I knew that you were seasoned professionals and you would handle it with grace, and you did. I commend you all. We will be in recess. Thank you.
All right.